pattern is created, this pattern of perhaps treating this child the wrong way, being too forceful, or what we would consider abusive that perhaps this adult doesn't yet see as abusive. And this continues. And there's nothing to suggest that it won't continue until there's something that stops it, some intervention, something that says enough is enough, this cannot continue. And oftentimes that something is the reporter that did that job of making that observation and stopping that cycle.
As a mandated reporter, you're legally required to report if you have knowledge or reasonable suspicion of abuse or neglect, and obtain this knowledge during the course of your work or in your professional capacity. Remember, you're not required to prove the abuse or collect evidence.
These are very delicate personal issues that are best left to professionals that are trained to investigate, law enforcement or child protective services.
You are not legally obligated to report if the knowledge or suspicion of abuse or neglect did not come to your attention in your professional capacity. You are not empowered to investigate the complaint and should not do so.
That's all it is. It's just reporting. I have a suspicion, a red light went off, I heard a ding in my head that there's something about this situation that's not right. And then put it in the hands of all the other authorities, all the other responsible people that are going to do that next step. And they don't necessarily have to worry about that. They don't have to worry about being liable. All they do is sleep well at night knowing they did what they needed to do.
Who you report to depends on the nature of the abuse. When a case is intrafamilial, you will usually report it to the Child Protective Services Agency in your county or by calling 911. When the abuse is by someone outside the family or in an out-of-home care setting, you will usually report to a law enforcement agency. These agencies will cross-report with each other in most cases. Reporting policies may vary by county, so it's important to know your county's policies and procedures. You are required to report by telephone immediately or as soon as is practically possible. You must file a written report within 36 hours on State Form SS 8572. This form is available on the State Attorney General's website and from county recording agencies, and may be submitted in hard copy, electronically, or by fax. Your reporting duty is not complete until the written report is submitted. The report must include your name, the child's name, the present location of the child, the nature and extent of the injury, and any other pertinent information. The report will be assessed by the investigating agency to determine whether or not there is a need for immediate action. Face-to-face contact will be made with the alleged victim, and an initial investigation will be conducted.
We'll do the basic investigation right then and there, and we'll determine if maybe we need to go get a warrant to take the children from the home. We'll determine if there's any prior report of abuse with the adults or the caretakers in the home. And we'll do a thorough investigation. If we need to go further, we can call out detectives, we can seek a warrant to take the children out of the home, or we can refer to the DA for further investigation, or we can unfound it right then and there.
It's probably important for reporters to also know that they are allowed to recontact the agency to which they originally reported, and in this way they can follow up on the case and find out the outcome and have that gratification that they actually made a difference.
There are some reasons people fail to report suspected child abuse. Denial, when the mandated reporter does not believe the incident could really be happening. Fear of making a mistake. Fear that the parent or parents will be angry and will take it out on either the reporter or the child. Belief that that nothing happens when you make a report, or that it makes things worse. Fear that a supervisor or coworker will be angry. Bias against the child in favor of the suspect. Regardless of the reason, failure to report suspected cases carries consequences.
Failure of a mandated reporter to report is a misdemeanor and carries a penalty of 6 months in jail, a $1,000 fine, loss of license, or a combination of penalties. If great bodily harm or death occurs as a result of a failure to report, the penalties increase. A mandated reporter could also be subject to civil liabilities for failing to protect a child. Reporting laws override ethical duties to protect privileged communications, except the clergy penitent privilege. Mandated reporters are immune from civil and criminal liability. Since January 2005, this immunity applies even if the mandated reporter acquires the knowledge or reasonable suspicion of child abuse or neglect outside his or her professional capacity or outside the scope of his or her employment. The immunity covers all conditions or instances, blanketed, but does not prevent nuisance lawsuits. However, there is a fund in California to reimburse legal costs up to $50,000 incurred by mandated reporters that need to defend themselves against these suits. Supervisors and other employees may not impede, inhibit, or sanction a mandated reporter for fulfilling his or her reporting responsibilities, or they may be charged with a misdemeanor and subject to the same penalties as a mandated reporter.
As a mandated reporter, you're afforded various protections by the law. In other words, if you make a report, you can't be brought to trial if that case was found to be an abuse case or not. You're protected by the law. So there's a lot of encouragement, because if you don't report, there are fines. There's also professional liabilities that you would carry. But the benefits of reporting are things that are very long-lasting. I mean, to take a child out of a situation that is cloaked in denial, that is cloaked in secrecy, frees that individual up to learn, most importantly, that it's not their fault that this happened, that they were the child and they were not the adult. As a professional working in any field where you're a mandated reporter, you're not only obliged to do that, but the rewards that you get you're the only person, you may be the only person that sees it. You may be the only person that recognizes those signs and symptoms. You may be the only person that witnesses the damage that the abuse has created. So it's why we're in these professions. It's why we choose professions of helping people and protecting children.
Children under the age of 18 cannot give consent to sexual acts. By definition, consent is not a defense. It is normal for children to be curious about their bodies and those of others, but extreme sexual preoccupation, experimentation, or adult acts may be indicative of abuse. Cases should be explored on a case-by-case basis. Children can be prosecuted for sexually abusing other children. The key component is use of coercion. Lewd and lascivious acts are reportable when a minor is under 14 and his or her partner is 14 or older, regardless of claimed consent. Sexual activity involving children under the age of 14 is reportable under any circumstance, even when both parties are under the age of 14. Consensual sexual activity between a minor and an adult is reportable abuse, as it constitutes child molestation. Due to the complexity of the laws surrounding consent of minors, a mandated reporter should err on the side of reporting and let the investigating agency make the decision. Remember, it is not the mandated reporter's duty or role to investigate.
And there is that adage that kids will be kids. And that's such a convenient way for some folks, not necessarily intentionally or maliciously, where they're really plotting that, but it's just a great way of dismissing. It's a great way of saying, I don't have to worry about that because kids will be kids. There is a line, and there's usually some process that clicks